Well, good morning. My name is Stephen Matty with the Legal Department. I'm going to go over the open meetings law, emails, walking quorums, negative quorums, and I think we're going to throw in a little bit of parliamentary procedure at the end, just for the icing on the cake. All right. First of all, just to make you aware of some things that we in the legal department are doing that have not been done before. Every year, we do an annual training now for City Hall. So in January, we do annual public records training. In July, we're doing annual open meetings training. The purpose of that is to go over all the new case law that's come out for the public records law. In January, what we did was went over with staff over particular topics that frequently occur, and also to address other issues. Right now, we are focusing on doing these things for staff first. Our long-term goal, though, is to also, for example, in the open meetings law, to then have training sessions also for all of our chairpersons, other officers, and other appointed officials who are interested in having open meetings training and public records training. Another thing, too, is council member handbooks. You need to look at your council member handbooks. There have been significant updates in those handbooks since the last time you've gotten them. A lot of issues about walking quorums and negative quorums are found in the back. Specifically, there are a memorandum dated July 12, 2007 on that issue that provides you with the best possible advice, and I guess we'll get to that a little bit later. The general policy in the open meetings law is that a representative government is dependent on an informed electorate. The public is entitled to the fullest and most complete information in the affairs of government. That means the public can show up, they can observe everything that's going on, they have the ability to hear everything that's going on. However, that does not mean, and there is no right to public participation whatsoever under the open meetings law. There is no right to speak, there's no right to participate from any member of the public under the open meetings law. Sometimes there are that are required, but those are under different statutes. So for example, we talked about the budget, we talked about the creation of TIF districts. Separate statutes may require that a public hearing occur, but under the open meetings law, the default rule is that there is no right to public participation whatsoever. The other exception to that would be unless you as a council decide to give public participation and allow a public hearing. So we have our council rules that do allow for public hearings at our committees and at our committee of the whole. And there are specific rules for that, but of course, every time we have that, there's always the motion. We go through the parliamentary procedure. There's a motion, a second, there's an actual vote. If that public hearing motion was ever voted down, there would not be a public hearing. Now, meetings law also states meetings must be publicly held in places reasonably accessible to the public and open at all times unless there is some reason to close it. There has to be a notice that goes out that has to say the time, date, place, and subject matter of the what's going to be happening at that meeting. It's presumed that if at least one half of the members of the governmental body is present, it's presumed that a meeting is occurring. Now, the actual test, though, to determine if a meeting has occurred is number one, was the group in governmental business, and number two, was there sufficient numbers of members present to determine the course of action for that particular item. So you have to look at defining what does governmental business mean and how many numbers of people. The numbers of people are the walking quorums and negative quorum issues that we're going to get to later. Governmental business, though, is defined broadly. It includes any decisions, any discussions, and it also includes just information gathering. This comes into kind of like what we talked about last Thursday. We talked about this meeting, and the question was raised about what if there's not 12 members here. We still have to notice that. We still have to notice this meeting under the open meetings law. It's called a bad key notice. If you want to be specific, referring to a specific open meetings law case, we put out a bad key notice so that here we are gathering some general information, but then there's also a distinction that can be made about information gathering about specific legislation versus information gathering that in this case is just generalized training. The open meetings law also requires that, does not require, it only requires that motions and votes are recorded. There does not have to be any detailed minutes whatsoever. You cannot go into closed session unless you have a specific reason to go into closed session. Those are all enumerated in 19.85 per N1. There's a long laundry list of items there. If we go into closed session, it has to be noticed on the agenda. The reason for going in closed session has to be stated by the presiding officer. There has to be a motion, and then there has to be a roll call vote. If everybody votes unanimously, you don't need a roll call vote. There is also an exception, even if it's not publicly noticed for going to closed session. You can still go into closed session as long as you still follow those requirements. But if you go into closed session in that circumstance without the public notice, you cannot come out and you cannot take any further action. You have to reschedule another meeting before you can take action on that agenda item. Some reasons for going into session, if you're deliberating in the quasi-judicial capacity, employment issues, bargaining reasons, conferring with legal counsel, and there's a number of other ones. Enforcing the open meetings law, there's a number of people who can enforce this. You have the Attorney General. You have the District Attorney can also bring actions. District Attorney would have to receive some sort of verified complaint. And if there is no action on that, then an individual at that point can then bring a private cause of action. I believe there's the statute of limitations is 2 years for that. Penalties, forfeitures can be imposed between $25 and $300 for each violation. Those forfeitures would go against the individual. And those forfeitures are generally not reimbursed by the municipality. So those would be personal liability if there was to be anything that occurred there. Additional things that can happen, if there is a violation of the open meetings law, a judge could come in and say that whatever action was taken is going to be voided. Now that's not an automatic, the action is not automatically voided, it's something that could occur. So there has to be a balancing test that occurs in that particular circumstance. One of the things that I was involved in, the most recent issue that I dealt with on the open meetings law since here at La Crosse was when the State Road School was annexed into the city, and then the town was trying to get the district attorney to seek to claim there was an open meetings law violation, and then to try and prevent that annexation from occurring. In that particular case, that school was brought in to the city because the city could provide water, whereas the town could not provide safe water for that school. In that case, if that went to a judge, more likely than not, the judge would not have avoided that action because it was a public health issue, and the safety of children were at issue in that particular case. We never got that far, but that's the type of analysis, that's an example of that, when the balancing test for when something would or would not be voided. Other relief that can happen is or declaratory judgment, and it can also give injunctive relief as well. All right. Emails are, because of the change in technology, create new problems under the open meetings law that we have not encountered before. So emails, when we talked about when does a meeting occur, we talked about numbers and we talked about governmental action. Well, in the old days, before computers, if you're going to do any type of written correspondence, you have to actually put something on letterhead, put it in an envelope, put a stamp on it, send it off. You don't have that direct interaction going back and forth. That's instantaneous interaction. Now with emails, instant messaging, texting, all those types of communications are now more interactive and more immediate. As a result, you can now have fall into walking quorum and negative quorum issues a lot more easily. As a result, that's why you always hear from us, do not engage in email whatsoever on any agenda topic at all. Do not press reply, do not press reply all, do not do anything with that. Don't send out those emails in the first place.